In the Court of Appeals, 8th Judicial District, Cuyahoga County, Ohio. Carrington Mortgage Services, LLC. Plaintiff Appellee, V.S. Princess Ada Israel. Defendant Appellant. Appeal No. CA 25-115296. Trial No. CV 24-999054. On appeal from the Cuyahoga County Court of Common Pleas. Objection: alleged due process violations, fraud on the court. Come now. Defendant Appellant Princess Ada Israel, Ms. Israel, objects to the striking her reply on November 26, 2025 and December 1, 2025. The court ordered Ms. Israel to resubmit her reply in accordance to Rule 16A2. C. The order and the rule are not the same. The order December 3, 2025 appellant brief is stricken due to exceeding pages. App.R.16A2. C. Which requires that the reply not exceed 3,000 words or 10 pages. In addition, a second order was attaching exhibits to a brief is not permitted. The Appellate Rule 16A2, C, last amended on November 3, 2025 states the following. Appellant's reply brief / cross appellee's answer brief. The third brief is the appellant / cross appellee's brief, identified on its face as a reply brief in support of the appellant's appeal and an answer brief to the cross appeal. The table of contents of the brief shall designate which portion of the brief is a reply and which portion relates to the cross appeal. The portion that is a reply in support of the appeal must not exceed 3,000 words, and the portion relating to the cross appeal must not exceed an additional 4,500 words. The reply portion of the brief must be restricted to matters in rebuttal to the answer portion of the second brief. A brief filed with at least 12-point type that does not exceed 25 total pages will be presumed compliant with these word limits. If the brief exceeds 25 pages, it must contain a word count certificate of compliance as stated in loc.app.r. 16a. 7. Ms. Israel's reply brief filed on November 26, 2025 in total words is 3,428 with 16 pages, which complies per App Rule 16A2. C. The brief also contains exclusions of pages and word count in App Rule 16, 5 exclusions from page limitation. All page and word count limitations are exclusive of the cover page, table of contents, table of authorities, certificates of counsel or self-represented litigants, signature block, certificate of service, and any appendices. Therefore, Ms. Israel word count is reduced to 3,105 words and 12 pages. According to App Rule 16A2, C, there are 7,500 words and 25 pages total allowed. This is somewhat confusing as it appears to be two portions to the reply. The support of the appeal has 3,000 words and the cross appeal has 4,500 words. There is no 10-page limit in this rule as the court ordered. Ms. Israel's fault on her reply was Rule 16, D, unnecessary attachments of legal authority disfavored. Parties are discouraged from attaching to briefs any legal authority generally accessible through online legal research databases. Only if the determination of the assignments of error presented requires consideration of legal authority not accessible through any online resources shall the relevant parts be reproduced in an attachment or appendix at the end of the brief. Attorney Gurchik attached exhibits to her brief starting at page 17 through 76. That's 59 pages attached that are all available online and part of the trial court records. The appellee's brief received no order from the court that attachments were not permitted. Ms. Israel's brief was filed with attachments starting from page 31 to 138. That's 107 pages attached. Nothing was ordered, nor was the brief stricken from the record, for attaching exhibits. Not until Ms. Israel showed the court clear and concise evidence of alleged document tampering, exposed redacted information, did the court remove the reply brief from court records and ordered Ms. Israel to refile her brief without exhibits. The appendix, exhibits, and arguments not presented in trial court was all that was needed to correct the reply. By striking both documents without addressing the tampering of documents violated her due process and was an abuse of discretion, as she raised and showed serious issues of document tampering within the Clerk of Courts. The Clerk of Court failed to notify Ms. Israel after their review of the document where 5 pages were not visible and request that she resubmit another copy. Ms. Israel has complied with the court removed exhibits, removed pleading not argued in trial court, reduced her reply to under 3,000 words within 10 pages. Under the court's order, however, there is a total of 15 pages. 5 pages are excluded from word and page count under App Rule 16. 5. Objection to Attorney Gurchik failure to send a paper copy. Ms. Israel filed a motion that the appellee's brief was not mailed. Attorney Gurchik filed no response or claim that she or her staff mailed the brief, yet the court agreed with Attorney Gurchik because it was stated on her brief. Attorney Gurchik's brief was filed after business hours at 23:22, late at night, followed by a holiday the next day. Attorney Gurchik forgot to instruct her staff to mail the copy and Ms. Israel called her out. Ms. Israel has a mail service. Every piece of her mail is scanned and time-stamped. Why would Ms. Israel subject herself to added filings knowing that Attorney Gurchik have a staff who can prove if a document was mailed or not? At a law firm, every piece of mail is valuable. Logs Legal Group, LLC have a very sophisticated system to track every single piece of mail, similar to what Ms. Israel have in place. Attorney Gurchik did not respond, because she could not produce the proof and she did not mail the copy. In a court of law, in the United States, when a party files an allegation and the opposing party fails to answer, the allegation is considered factual for failure to defend. If Ms. Israel failed to defend an allegation, the court would have dismissed the case for failure to defend. Attorney Gurchik's allegations would have been found factual. The court would not have protected Ms. Israel by saying it was on her papers filed, therefore she filed the document. At a click of a mouse, Attorney Gurchik can access a log of all letters mailed to the Cleveland Heights property and the Fort Worth address, coded and time-stamped. Law firms keep meticulous records of mail because of due dates and preservation of evidence. Again, the plaintiff is granted another, out of abundance of caution, is used to protect the wrongdoings of Attorney Gurchik and violate Ms. Israel, to order a copy, to include the appellee's brief for review because the filing is not complete without completing the service. The court erred in allowing a document to be mailed when the appellee failed to file any answer in the defense of the allegation made or produce a shred of proof that the document was mailed. According to the court, because Attorney Gurchik stated in her brief that she mailed a copy, that was all the proof needed. Therefore the certificate means nothing if a court assumes it was mailed based on the certificate page included in the court filing. Ms. Israel was instructed to mail copies to Attorney Gurchik. Failure to do so would be grounds for dismissal. In doing so, Ms. Israel has taken great steps to comply with the court. She wears a body cam while mailing her documents at the post office. She has a receipt from postage. In the event if Attorney Gurchik filed a motion that she did not receive a filing, Ms. Israel would not hesitate to present video and receipts to dispute any claims. After which the court could make a fair assessment based on the facts presented, if Ms. Israel mailed the filings. Attorney Gurchik received Ms. Israel's brief from her mail service in Fort Worth, Texas for additional protection, extra witnesses, tracking, and it was cheaper to print a large file from the mail service. Ms. Israel objects to the court mood of documents. An alleged crime was committed. Fraud on the court. Document tampering and exposing redacted sensitive information was not addressed because she exceeded pages and included exhibits. Ms. Israel respectfully raised the above objections as she believed her due process was violated and there was prejudice to allow Attorney Gurchik to mail a copy of her brief without any defense to the allegations. Rule 16 was enforced upon Ms. Israel after she made allegations of document tampering by the Clerk of Courts. The appellant's brief or appellee's brief were not stricken from the docket for adding attachments. Ms. Israel has been under a cloud of threats of dismissal since filing in the appeals court. The attorney and clerk of courts have allegedly committed violations and serious crimes were not addressed. Blocking access to her e-file account was not addressed. The officer of the court can violate Ms. Israel, and when she strikes back with compelling evidence, the court orders are reflective upon Ms. Israel and the officers continue their violations and crimes against Ms. Israel without reprimand. At all times a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2, a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3, a. b. And ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6, a. Under Ohio Constitution Article 116 and the 14th Amendment, due process. Ms. Israel believe her rights were violated. Respectfully submitted. Underscore 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 underscore. Princess Ada Israel, Pro Se. 4364 Western Center Boulevard, Suite 5077. Fort Worth, Texas 76137. 303-552-3777. 2591 Lee Road @gmail.com. 12 Certificate of Service. A copy of the foregoing brief was sent pursuant to App.R13, by United States Postal Service's regular mail on December 4, 2025 to Tamara E. Gurchik, 4805 Montgomery Road, Suite 320 Norwood, Ohio 45212. Underscore 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 on. Princess Ada Israel, Pro Se. 4364 Western Center Boulevard, Suite 5077. Fort Worth, Texas 76137. 303-552-3777. 2591 Lee Road @gmail.com.